Good morning. Welcome to Deb's True Crime Notebook. We have more documents. Yes, we do. And we have an appearance of a new attorney and a new doctor to be subpoenaed. So let's get into this. State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. Notice of temporary or limited representation. Party classification, responding. 1. The undersigned attorney and all attorneys listed on this form now appear in this case for the following party: Jessica Fidler, M.D. For the limited purpose of filing motion to quash deposition subpoena for deposition scheduled for August 28, 2024. 2. Applicable attorney information for service. Name: Peter H. Pogue. Attorney number 14631-49, Schultz and Pogue, LLP, 520 Indiana Avenue, Indianapolis, Indiana. And it's respectfully submitted by Schultz and Pogue, specifically Peter H. Pogue. State of Indiana, County of Carroll, State of Indiana versus Richard M. Allen. Motion to quash subpoena. Jessica Fidler, M.D., by counsel pursuant to Indiana Trial Rule 45 and Indiana Trial Rule 26, respectfully moves this court to quash the subpoena ad testificandum issued to her by the defendant in the above captioned matter. In support of this motion, Dr. Fidler states as follows. 1. Dr. Fidler was served a subpoena commanding her to appear for a deposition on August 28, 2024, in the Carroll County Courthouse, Circuit Court Jury Room. The subpoena was issued in connection with a criminal proceeding in which Dr. Fidler is not a party. This subpoena does not comply with Indiana Trial Rule 45D2, which requires a deponent to attend a deposition only in the county in which they reside or in which they conduct business. Dr. Fidler is a physician practicing medicine in Greencastle, Putnam County, Indiana. 2. The subpoena also provided only 9 days' notice before the scheduled deposition. Dr. Fidler is a licensed medical doctor practicing in Greencastle, Indiana, with a demanding patient schedule. This short notice period is insufficient to allow her to adjust her professional obligations and comply with the subpoena without significant disruption. 3. Under Indiana law, reasonable notice for serving a subpoena to a witness, particularly in the context of depositions, is not explicitly defined by a specific number of days. However, Indiana courts have interpreted reasonable notice to mean notice that is reasonably calculated under all the circumstances to afford the interested parties an opportunity to present their objections, and must reasonably convey the required information to the affected party. Squibb v. State, ex rel. Davis 860 NE 2D 904, Indiana Court Appellate 2007. 4. Indiana Trial Rule 30 and Rule 45 provide additional guidance regarding the schedule of depositions. Rule 30b-1 requires that notice of a deposition must be given to all parties before a subpoena can be issued. The Elkhart County Rules of Court further specify that unless otherwise agreed by counsel or authorized by the court, no deposition shall be scheduled on less than 10 days' notice. Indiana Elkhart County Rules of Court, LR 20-TR 26-218. Discovery requests. Although these specific rules pertain to Elkhart County, they reflect a general standard that is instructive of other jurisdictions in Indiana, including Carroll County, particularly when considering what constitutes reasonable notice. 5. The subpoena served on Dr. Fidler did not include the necessary witness and mileage fees as required by Indiana law, Indiana Code 33-37-10-2 and 33-37-10-3. Govern witness fees and mileage fees, which apply to both civil and criminal proceedings. Indiana Code Chapter 33-17-8 extends these provisions to criminal cases, ensuring that witnesses in the criminal proceedings, including those participating in depositions, are entitled to the same statutory fees as in civil cases. For a deposition during her normal business days, Dr. Fidler charges $350 per hour for a deposition. 6. In light of the insufficient notice period, the professional obligations of Dr. Fidler, and the failure to tender the required fees, the subpoena is unreasonable, burdensome, and legally deficient. For these reasons, Dr. Fidler respectfully requests that this court quash the subpoena issued to her and relieve her of any obligation to appear for the deposition on August 28, 2024. The failure to provide reasonable notice and the omission of mandatory fees each independently justifies quashing the subpoena. Wherefore, Dr. Jessica Fidler, by counsel pursuant to Indiana Trial 45 and Indiana Trial 26, respectfully requests that this court grant the relief requested herein and all other just and proper relief. Respectfully submitted, Schultz and Pogue, LLP, specifically Peter H. Pogue. And there you have it. We have the appearance of a new attorney that will be representing Dr. Fidler, who has been asked to appear for a subpoena. And apparently the legal request, the subpoena was not done accurately. That is a shocker. So we'll see if it's submitted or resubmitted with a new date, time, and the actual fee that applies to her. And if that comes through in the next few days, we'll let you know. Thanks for watching Deb's True Crime Notebook. Please like, subscribe, leave us a message, ring the bell for all notifications. And if you can, share this with a friend or in the groups that you participate in.